Well, good morning, everyone. We're going to get started with our webinar. Thanks for joining us today for our 10th webinar that we've done in the last 10 weeks. So we appreciate those. I know many of you have joined us every week, and we appreciate that. Hope you've enjoyed these presentations, and we'll continue to listen in as we continue to offer these for the very, at least through the month of July. We know we're going to be doing them. As we begin today, remember to keep your microphone muted and post any questions that you have for our speaker to the chat box, or any other questions or comments that you have. One of the things I always ask people during these introductions is if there's a webinar topic that you'd like to hear about, please post that in the chat box, and we'll make every effort to try to get that into our schedule. So I know we have a lot of great topics coming up that you'll want to listen into. So today, first thing we want to do today is thank our sponsor, which is the Bank of Hillsborough. And the bank is now celebrating its 150 years in business with 12 branches in South Central Illinois, including one here in Effingham on North Keller Drive, and also one in Altamont. They are a full service bank supporting personal and commercial banking and loans, and we thank them for being our sponsor today, today's webinar. So to get started introducing our speaker, just to since the beginning of the COVID-19 pandemic, many programs have been put in place by the state and federal government to support employers and employees. Among them is expansion of unemployment insurance benefits. And now as businesses begin to reopen, bringing our workforce back to work safely is a key concern for all of us. There are also financial and legal implications that employers need to be aware of. So we're pleased to welcome Scott Cruz with Greensfelder Law Firm that has offices in St. Louis and Chicago to make the presentation today. Scott represents public and private sector employers in all aspects of labor and employment law, including civil litigation and preventative counseling. He represents employers in state and federal courts and administrative agencies involving claims brought under the Title VII of the Civil Rights Act, the Americans with Disabilities Act, Family and Medical Leave Act, Age Discrimination and Employment Act, retaliatory discharge, breach of contract, labor arbitration, and class action. He's particularly versed in all aspects of state and federal law relating to minimum wage, overtime exemptions, and wage payment issues. So please welcome Scott Cruz.
Thank you, Norma, and good morning, everybody. Thank you for joining us today on this very important topic. Unemployment benefits and unemployment insurance has certainly been an issue in the forefront of this COVID pandemic, right? With so many different, with many employers furloughing their employees and laying off their employees and or even terminating their employees, right? And there's so many questions that employers have had, employees have had regarding this topic. One thing I will say at the beginning, and I generally say this when I'm talking about unemployment insurance, our employees will be looking to us for guidance, right? My recommendation and advice to my clients, which I will tell you today, is do not provide any assurance one way or another that someone will in fact be eligible or will in fact not be eligible, right? As it relates to the latter, there is a provision in terms of, if you tell somebody, well, if you apply, you're not going to be eligible. These are determinations made by the Illinois Department of Employment Security. The information I give here is based on what the law says, but at the end of the day, right, the IDES is the one that makes these decisions. More importantly, however, what I tell my clients is why I don't want you providing assurances one way or another is there's a retaliation component under the Unemployment Insurance Act. And if you were to tell one of your employees, right, who you know is going to furlough, you're not going to be eligible for unemployment. So I would advise that you not do that. Right? Someone arguably could claim that you've retaliated against them by trying to dissuade them from applying for unemployment benefits. Remember that employees always have the right to apply for unemployment benefits, right? If you ever enter into a release or a separation agreement, never include a provision where it says the employee agrees to waive his or her right to unemployment benefits. It's void, and you'll get in trouble from the IDES for that. So what I tell my clients is when they get that question from the employee, your response is, you should do what you believe to be in your best interest, right? That's the response that you should provide to your employees. So with that, let's get started on the content today. Next slide, please. Okay, so let's talk about what an employee is actually eligible, right? In terms of, we know that employees always have the right to file for unemployment, but there's certain baseline monetary requirements that an employee must meet before they even become eligible, right? And under the Unemployment Insurance Act, an employee must have earned at least $1,600 during his or her base period. And by base period, I mean 4 of the last 5 calendar quarters prior to the time he or she applies for unemployment. So generally, it's a small amount. Most of the times employees will meet that. And quite frankly, the IDS will look back, even if the employee did not make that $1,600 with you, they will look back to the prior employer to essentially add it together, right? To say, okay, they made $900 with employer A, and then if we go back for the last 5 calendar quarters, they made $800 with this other employer, right? So the employee made $1,600. We're going to make him or her eligible. So while there is a stated monetary amount, the IDS essentially goes out of its way to make sure that the employee meets that. I get the question, was there an hours requirement? No, there's not. The employee could literally work 5 hours so long as he or she made $1,600 during that base period, and subject to any disqualifications, he or she will be eligible. What about you, right? The employer. When do you become what's called the chargeable employer? And what is the chargeable employer? So you'll hear the term and you'll see it on your notice of benefit that you got from the IDES. The chargeable employer means that you're the employer who's going to get charged for this claim, right? Your account will fund this unemployment compensation benefit. So when you see chargeable employer, it means you're on the hook for this. How do we determine who's the chargeable employer? The chargeable employer is the employer who the individual worked for 30 days, doesn't have to be consecutive days, prior to him or her filing a claim. So for example, if I worked for the chamber beginning, let's say on May 1st, right, and I filed a claim today, the chamber would be the chargeable employer because I provided 30 days of service to the chamber prior to filing my unemployment claim, right? And so what I generally tell my clients, if you don't want to be the chargeable employer, right, you have to be thinking about this. Make the decision as to whether or not that employee you believe will continue to work for you if he or she is not meeting expectations. Let them go prior to day 30, right? Internally, have day 25 marked on your calendar, right? Make an assessment after day 25. I know a lot of companies have a 90-day probationary period, which I generally don't recommend, but that's another webinar. Look at it by day 25 and say, hey, do we think Scott will, be a good employee for us, right? We've got another 5 days to figure this out. Because once day 30 happens, you're on the hook for unemployment benefits because I provided 30 days of service to you. Again, days do not have to be consecutive. Next slide, please. Okay, so one thing that most employers are not aware of, when you terminate, when you lay off, when you furlough an employee for more than 7 days, you are required to provide the employee with a pamphlet from the IDES entitled "What Every Worker Should Know About Unemployment Insurance." If you go to Google and put in that "What Every Worker Should Know About Unemployment Insurance," it'll come up printed out. Any single time, anytime you terminate, you lay off an employee, and again, particularly lay off or furloughs for more than 7 days, you're required under the Unemployment Insurance Act to provide this pamphlet to the employee, right? If you haven't done so, don't worry about it now. Moving forward, do so, right? Provide it on the last day. If you haven't done so, you've got, I think, 5 days to do so. So email it to the employee, mail it to the employee. But the Unemployment Insurance Act requires that you provide this pamphlet to any employee, again, when the separation is for more than 7 days. Next slide, please. Okay, so our employees who are temporarily furloughed or laid off due to COVID-19, are they eligible for unemployment benefits, right? That was the big question, and quite frankly still is, for employers during this pandemic, because many of my clients, many employers were temporarily furloughing and laying off their employees. Now, I want to make a quick distinction. The IDES uses the term layoff, right? A layoff, in essence, is no different than a furlough. If you've temporarily laid off someone, it's no different than a furlough, right? So when I use the terms furlough and temporary layoff, they're one and the same. So the answer to this question, are employees who are temporarily furloughed or laid off due to COVID-19, are they eligible for unemployment? The answer is yes, right? So long as, right? Yes, so long as they meet the usual eligibility requirements, right? So we know there's that $1,600 requirement. In addition to that, right? In addition to that, the individual must have been separated from employment through no fault of their own. Of course, if someone's laid off, right? There's an involuntary layoff. It wasn't their fault, right? So they'll meet that. But also they have to meet the requirement that they're able and available to work. And that means that during this time that they're laid off, that they're able to do some work, right? Able to perform some type of work. Now, where we see this coming up is individuals, for example, who are diagnosed with COVID and who are, for example, bedridden, right? Or in the hospital, right? And they apply for unemployment benefits. Unfortunately, those individuals, they don't meet that latter requirement, right? They're not able and available to work because they're in a hospital bed, right? So unfortunately, those individuals will not meet the requirement, even if they've been temporarily laid off, right? Due to COVID-19, because they're not able and available to work. Now, as part of this pandemic, if you look at the last kind of bullet point here, generally speaking, when someone applies for unemployment, they also have to prove that they're actively seeking work, right? We can't just sit home on the couch and not do anything. When an employee has been laid off under this pandemic and just for this pandemic, Governor Pritzker waived the requirement that individuals must actively be seeking work. Why? Because no one was hiring, quite frankly, during this pandemic, and a lot of employers aren't hiring during this pandemic. So what makes sense to require folks to be actively looking for work. So what Governor Pritzker stated and what the IDES, what the Insurance Act provides now is, so long as when your employer opens up their doors and says, okay, you're no longer laid off, you're no longer temporarily furloughed, come back to work. So long as you are prepared to come back to work, that will meet this actively seeking work. The employee who says, no, you know what, I'm not coming back, I'm going to retire. That employee will not meet this actively seeking work, right? Because they're not prepared to come back to their job once their employer reopens, right? So it's a very important distinction. Next slide, please. Okay, so the big question I've been getting as well, employers' contribution rates, right? Will they increase each time an employee gets benefits because they've been furloughed or laid off due to COVID-19? Now, stress, this only relates to if an employee has been furloughed or temporarily laid off. Any other basis of separation, this does not apply to. As of today, the answer is no. Your contribution rate will not increase if you have laid off or furloughed an employee between the time period of March 15th and December 31st, 2020. These costs will be socialized in the system. What does that mean? You may not see a reflection of an increase in contribution rate now, but guess what? After December 31st, 2020, you will see this, right? You and every other employer's contribution rates will increase, right? because it has to. In essence, the Department of Employment Security is broke. They have no money right now. They have to borrow money from the federal government. They've looked for a loan for the federal government. I saw something, read something the other day of almost $8 million, right? Because they're broke. So while your contribution rates will not increase if you furloughed or laid off somebody and they get benefits between that time period, expect to see not only yours, but everybody else's everybody else's will increase probably after December 31st, 2020. Also, know that, remember, there's that CARES Act provision, which we'll talk about. That additional $600 per week that people are getting through July 31st, 2020, that benefit is wholly funded by the federal government. Therefore, you're not a chargeable employer for that. Your fund will not be charged for that additional $600 that the federal government is paying essentially to the states for the states to pay you. Next slide, please. Okay. What if, and this is again another one of the, I guess I'll say the top 5 questions that I'm getting, right? The scenario is this, right? You're ready to reopen your doors. You're ready to bring back the employees, and you furloughed or laid off them, and you make an offer of employment to me. You say, Scott, I've got great news. We're opening up. We want you to come back. Same job, same position. And I tell you, no, I'm not coming back. Quite frankly, I'm doing well collecting unemployment. So thanks, but no thanks. Am I eligible to continue, right, getting unemployment? The answer here is possibly. Right? And I say possibly because it depends on the reason that I provide to you on why I don't want to come back to work. Using my hypothetical, if I tell you, no, I don't want to come back to work, quite frankly, it's more financially beneficial for me to stay on unemployment. Guess what? I'm going to be ineligible for unemployment, and I'll tell you how to make sure that I don't continue to collect unemployment. Using a different hypothetical, if I tell you, I don't want to come back to work because I know employees are there already. And from what I've heard, you have not implemented any safety protocols that the CDC has recommended, that Governor Pritzker has recommended. So until you implement those, I am staying at home collecting unemployment. In that scenario, an individual likely, the IDES will be the final decision maker, could continue to stay home, right, and collect unemployment if, in fact, what they're saying is true, right? If you have not implemented any safety protocols, that individual, right, I've told you about it, I've given you an opportunity to correct that, right? And until you correct it, if I want to stay home, to the extent it's true, until you correct that, there's a chance I could continue collecting unemployment. But if I tell you, no, I'm not coming back, I'm just doing better collecting unemployment, that in of itself, the individual, I can tell you with about 99.9% certainty, will not and should not continue to collect unemployment. Now, what happens, next slide, please. What happens when that scenario does happen, right? Where the employee says, listen, I'm not coming back to work because I think it's more beneficial for me to stay on unemployment. Well, the IDES, if you go on the IDES's webpage, and if you go into the employer section, there is this form here. It's called Refusal of Work Reporting Form. You fill this out. You fill it out for each employee, right, who's refusing to come back to work. And you look at the box at the bottom, the 1, 2, 3, 4, 5, 6. What was the specific reason the employee gave for refusing to return to work? Make sure you are explicit and specific here, right? Scott's reason for not going back to work is he believes it's more financially beneficial for him to remain on unemployment. That's what you include in there, right? So for every employee who you make a legitimate offer to come back to work, right, to their same position, same hours, same pay, right, and they tell you no, you fill out this form and you submit it to the IDES. The IDES will look at this and make a determination as to whether or not the employees on here will be eligible to continue collecting unemployment, right? So you have to fill this out though, right? If you don't fill it out, the IDES will never know, right? So make sure you fill it out. I've got a question here from someone. It says, if someone has been furloughed, Are they allowed to volunteer at the same business that they were furloughed from and continue to draw unemployment? I'd be very careful with what you consider volunteering. Because if an individual is performing services for you, and they're performing the same services they were doing that you were paying them for, then that individual is not a volunteer, right? That individual is an employee. And if you're dictating, hey, you're a volunteer, but come in 9 to 5, work Monday through Friday, that individual is an employee, right? So there's that one distinction. I'd be very careful when I hear this volunteer. A lot of folks aren't properly treating someone as a volunteer. But that being said, if someone, so in that scenario, if you're not, technically speaking, if you're not paying somebody, they're not getting any wages, right? They can continue to collect unemployment. But I'd be careful because that can come and backfire on you if the employee can file a wage claim against you and say, I'm not truly a volunteer. I'm performing the same services that I was as an employee, and my employer is not paying me. So I'd be very careful in that scenario of bringing someone back as a volunteer. If someone is furloughed, they are furloughed, and they shouldn't be performing any work. Okay, next slide, please. So this form here, right? This form is for you to report anyone who is collecting unemployment, and they shouldn't be, right? Who's committing fraud, right? So if you know, for example, let's say you have furloughed someone, and you know that that individual got another job, right? Got another full-time job, and you still see that you are getting charged for unemployment. If you go on the IDES's website, this is the form. There is a section under the employer tab that says report fraud. Click on that section. This box, this link will pop up. This first box here, why are you contacting IDES? There's a drop-down box. There's a section in that drop-down box that said reporting fraud, right? This is how you report any employee who you know is working, collecting unemployment, and shouldn't be. Right? You don't want to continue being charged when you know that the employee should not and is not eligible for unemployment because, for example, they have another job. Right? So I want to make everybody aware about this because a lot of times employers tell me, "Hey, I know Scott's working for the company down the street, but I'm still getting charged. What do I do?" This is what you do, right? You fill out this form, you submit it, let IDES take care of that. Next slide, please. Okay, so what happens, right? This pandemic's not going away, right? More people continue to get COVID. So this question will still be posed and be an issue that we as employers have to address. If an employee is quarantined at home, one, to care for a family member, right? Spouse, child, mom, father, or him or herself has been diagnosed with COVID-19. Is the employee eligible for unemployment benefits? And I say here, potentially, right? Potentially the employee may be eligible. Why? Because they still have to meet all of the eligibility requirements, right? The $1,600 and for the last 5 calendar quarters, right? Now, again, this able and available to work, that may be what trips them up here, right? If someone says, listen, I need to care for my spouse on a full-time basis, right? So he or she needs around-the-clock care. Well, that person is not able and available to work. He or she likely won't be eligible. Now, remember I talked about how Governor Pritzker waived that requirement that folks have to be actively seeking from work? Well, that only applies when someone's been laid off or furloughed, right? In this situation, that actively seeking work requirement is applicable, right? That individual, to the extent they haven't been furloughed or laid off, they're just off of work because they've been told to self-quarantine. Well, they have to meet the actively seeking work requirement. Can they do so? Pretty easy to do potentially. If someone's bedridden, right, in a hospital because they have COVID-19, likely not going to meet that, right? So there's a lot of considerations here, which is why in the beginning I told you, and I wanted to get that out before I forgot about it, do not make any assurances to your employees as to whether or not they will be eligible. There's so many different considerations that the IDES looks into, right? Any one of these, right, you would think, well, hey, if you're off due to COVID-19, yes, you'll get it. Not necessarily so, right? You still have to be there, able and available to work. You still have to be actively looking for work, right? So that's why I advise all my clients, do not make any assurances on whether or not someone will be eligible for unemployment. Next slide, please. All right, what if, and this has happened a lot, I've got this from my clients, the employee quits, right, due to COVID-19 concerns, right? So the employee tells you, I'm not coming to work anymore because I don't believe that you are following Governor Pritzker's guidelines. Or the employee says, listen, I don't want, quite frankly, I'm just paranoid, right? I don't want to step foot out of my house. I feel that if I step foot out of my house, I'm going to get COVID just by breathing the air, right? Is that employee eligible for unemployment benefits? The answer again, possibly, right? What does it depend on? It depends on the reason that the employee gave you, right? I gave you two examples. The employee who says, I've been back to work now for a week, and this is what Governor Pritzker's recommendations are for the opening up, let's say, your manufacturing facility, right? And you have not implemented any of those. Not a single one have I seen. You're not giving anybody masks. You're not making sure that we are socially, that you're not doing staggered shifts, right? There's on the assembly line here, we are not social distancing. You're not requiring that. I'm not coming back. So I quit, right? Because you're not following these guidelines. Now, before the employee, right? So let's use that scenario first. Under that scenario, look at the third bullet point. Before the employee can become eligible, he or she has to provide you with a reason, with an opportunity to remedy that. So if I tell you today, I'm quitting for the reasons I just talked about, I'm not coming back to work, I go apply for unemployment, it's a good possibility I will be found ineligible because the IDES will ask that employee, did you give your employer an opportunity to remedy what you felt to be safety concerns? And if I say, no, I just quit on the spot, guess what? Likely going to be ineligible. Employees have to give us a reasonable opportunity to resolve what those issues are, right? If the employee says, yeah, I gave them 3 days to do it, and after 3 days, they still weren't providing us with any masks, they still weren't doing X, Y, and Z, likely going to be eligible. Now, the employee who says, I don't want to step foot out of my house, I'm too paranoid, right? Likely ineligible, right? Because remember, under the Unemployment Insurance Act, an individual who quits voluntarily, and we'll talk about that in the next slide, without a good reason attributable to the employer, right, generally disqualified from receiving unemployment benefits. So under my two examples, the one employee who quit because you're not following safety protocols under Governor Pritzker's Restore Illinois guidelines, well, they're going to argue that's a good reason attributable to you, right? The employee who quits because he or she is too paranoid to step foot out of their house will argue that has nothing to do with us, right? True voluntary resignation, we're not liable for that. Next slide, please. So I want to talk about very quickly what a voluntary resignation is, because this question comes up a lot, right? For an individual separation to be truly voluntary, right, the individual must have had the option to remain employed. What do I mean by that? The IDES, whenever we mark, right, when you get that notice of benefits and you mark voluntary resignation, when you submit that back to the unemployment, the IDES, the first question they're going to ask the employee, and then you as the employer, is this: if Scott did not voluntarily resign, did he have the option to remain employed? And if the answer is yes, of course, true voluntary resignation. If the answer is no, we would have fired him then, not a voluntary resignation, an involuntary discharge, right? That comes up when the employer gives the employee this Sophie's choice option, right? We're going to fire you, Scott, but you can resign instead of being terminated. And I say, fine, I choose to resign. That is not a true voluntary resignation. A lot of employers think it is because they say, well, the employee voluntarily resigned. Once the IDES peels back the layers, which they will, right, and ask me, did I have the option to remain employed? And I say, no, not a true voluntary resignation. The other thing here very quickly, if an employee submits let's say you require 2-week notice, right? The employee submits here his or her 2-week voluntary resignation. And you say, thanks, you know what? We'll accept your resignation. You don't have to come into work for the next 2 weeks. That has happened now. A lot of employers do that for many reasons, right? If you do that, know this: that employee will be eligible for unemployment for that 2-week period. For that 2-week period, it is an involuntary separation, right? After that 2-week period, that employee will no longer be eligible for unemployment. So keep that in mind when you accept the resignation and say, you don't have to give us the 2-week notice, go home now, right? Unless you pay the employee for doing that, then they'll be ineligible. Next slide, please. So when someone has a true voluntary resignation, right? This is the form you fill out. You get this on the IDES website. You can fill this out, submit it with your protest. So we won't have to talk about that enough. I just want to make everybody aware about this form on the IDES website. Whenever someone is truly voluntary left employment, make sure you fill that out and submit it with your protest. Next slide, please. Okay, so another one of the top 5 questions I've been getting. Employee quits because school or daycare is temporarily closed, right? And the employee tells you, I need to stay at home with my child. Is this employee eligible for unemployment benefits? Once again, the answer is possibly. So ordinarily, right, if we weren't in this pandemic, someone who quit, right, because they had childcare issues, that would be a voluntary resignation, right? Not attributable. The reason they left has nothing to do with you, right? So the reason it's not attributable to you, that in person, generally speaking, would not be eligible for unemployment. It'd be considered a voluntary resignation. Now, what about in this pandemic, right? So in this pandemic, we know school year is over, right? School year is over. So we now turn to daycare, right? Daycares are open now, right? Under phase 3, daycares were open. Phase 4, daycares are open as well. So what if the employee tells you, and this is the question I've been getting, I need to quit because my daycare, right, it is open, but they've got a limit on the amount of kids that they are taking, right? They're only taking 10 kids and I didn't meet the cut. So I need to leave. That employee files for unemployment. Contest that, right? Again, you contest it because it is a voluntary resignation. The reason for the resignation is not attributable to you, right? It's sad, understood, that you don't have childcare for your child, right? But guess what? Even though that daycare center may not be able to take your child, there's others out there, right? There's others out there. What about the employee says, I've got this question as well, that I can't afford daycare anymore, right? So I need to quit because I need to be home with my child. Again, we feel sorry for that employee, right? And if that employee files for unemployment, that is they should be deemed ineligible, and you should protest that because again, it's a voluntary resignation, and the reason is not attributable to you as the employer, right? So keep that in mind because those questions are coming up now. Again, schools are closed, but we're talking about daycares, summer camps. So to the extent, most of them are open, right? Even here in Chicago, most of them are open. Daycares. So, again, entirely up to you whether you want to contest it. But if you do, I can tell you, you'd likely win that protest because they're open and is a true voluntary resignation. Again, the reason is not attributable to you as the employer. And again, that individual still has to meet that actively looking for work and able and available to work as well. Next slide, please. Reduction in weekly hours. So another one of the top 5 questions I've been getting. So this scenario, this is the scenario, right? I work 40 hours a week. You tell me that instead of 40 hours a week, I'm going to be working 25 hours a week. I go apply for unemployment. I'm still employed, right? I'm still employed, but I apply for unemployment because I'm not working 40 hours a week. Am I, as an employee, entitled to unemployment? Again, the answer is possibly. What is the analysis here? The analysis is this. My weekly benefit amount, right? Is my weekly benefit amount, is that more, right, than the amount I'm getting each week from you for those 25 hours of work? If it is more, right, so let's say my weekly benefit amount, and again, the lowest someone would get is $51 per week. Maximum with dependents is about $667. So let's say, for example, my weekly benefit amount is $550. Is when I'm working those 25 hours, right, am I making more than $550? If the answer is yes, I'm not eligible. If the answer is no, right, if I'm getting $500 per week, the answer is yes, I'm going to be eligible. And I'll get the difference between the $500 and the $550, right? So that's the analysis. If you reduce somebody's hours, you reduce somebody's hours, if what you're paying them, even with the reduction in hours, is more than what their weekly benefit amount is, not eligible. If it's less, eligible. Next slide, please. Okay, rotational furloughs. What are we talking about here? First and foremost, are employees on rotational furloughs eligible for unemployment? Again, the answer is potentially. What are rotational furloughs? Rotational furloughs are this. I work, let's say the month of June. I work the first week of June, I'm on furlough the second week of June. I work the third week of June, I'm on furlough the fourth week of June, right? That is what's called a rotational furlough. Will I, as an employee, be eligible, right? Because I'm still employed, right? I'm still employed. Will I be eligible if I'm on a rotational furlough? The answer is it depends. It really depends on how the IDES looks at this, right? People are still being furloughed and through no fault of their own. So likely, right? But I've seen that go both ways. And quite frankly, now that the IDES is broke and they're being more stringent on claims that they are approving for benefits, they may not be, right? They may not be eligible. Again, this is strictly an IDES determination. Again, it's another reason I keep stressing we do not want to give assurances to our employees that they in fact will be eligible. Next slide, please. Okay, so another one of the top questions I'm getting, let's say we do furlough or lay off somebody, right? And that individual uses PTO, right? Or paid time off or vacation during that time period. Will that affect, right, the individual who uses PTO or vacation, will that affect their eligibility or will that cause a delay in unemployment compensation? The answer is yes, right? The answer is yes. So the scenario is this. You tell me, Scott, we are temporarily laying you off for a month, right? And I've got 3 weeks of PTO. And I tell you, okay, I want to use my 3 weeks of PTO while I am temporarily laid off. I file for unemployment benefits, right? I will not, now I'm going to be eligible because you furloughed me, you've laid me off, right? But I will not collect unemployment until after week 3. And the reason is this. PTO, vacation pay, sick leave pay, it's what's characterized or constitutes disqualifying income under the Unemployment Insurance Act. In essence, the IDS looks at that as wages, right? So while an employee is receiving wages, he or she is temporarily not eligible for unemployment. Now, in order for this to happen, right, when you get your notice of eligibility form, it's generally a 2-page form. Look on the reverse side of that form, right? If it's double-sided, there's going to be a box there that says, is the individual, have you paid out, right, particularly if it's a separation, or is the individual using vacation or PTO pay? You have to mark that box, right? And then you have to include on the bottom of the second page, it will say, identify the time period in which the individual is using PTO or vacation. You have to fill that out. If you don't fill that out, then I am going to be automatically eligible for unemployment. And note too that employees now during this pandemic are automatically ineligible. Prior to the pandemic, there was a 1-week waiting period before you got benefits. That 1-week waiting period has been waived. So now, for example, if I file a claim today, right, and I'm eligible, I can start collecting tomorrow. Now, I won't because the system is completely broke and it's going to take a while for me to get my money, but I don't have to wait a week now before. So again, employees who use PTO or vacation, that's disqualifying income. It will delay, right, when they get unemployment. But you, as the employer, has to notify and let the IDS know that, right? You'll see that on your notice of eligibility form. Make sure to fill that out. Next slide, please. All right, fringe benefits. Can you as an employer, can you continue to provide fringe benefits? Can you continue to provide, or can you provide severance when you terminate someone, or 401k loans if someone asks for them, or COBRA health insurance? And if you do so, will this affect or delay an employee's unemployment, affect or delay an individual's ability to collect unemployment? So let's go through each of these. Fringe benefits, right? If you continue to provide fringe benefits, right, while someone is furloughing, on furlough or laid off, no, this will not. If you provide fringe benefits to an individual, this will not be considered wages, and that will reduce an employee's unemployment benefits. So it's not going to affect it, right? What about severance? Severance may be paid. Will this affect someone? Now, I have yes here. This should be no, actually, right? If you provide severance to someone, severance will not affect. Oh, I'm sorry. I'm reading my question wrong. Can an individual continue to collect unemployment? Okay, going back to fringe benefits, I apologize. Fringe benefits will affect an individual and will affect an individual's ability to collect unemployment. Severance will, an individual can still collect unemployment and get severance, right? And it doesn't matter if the severance is paid periodically, which sometimes happens, or you do in a lump sum, right? Severance does not affect an individual's ability to collect unemployment. 401k loans, if you give a 401k loan, an individual still could collect unemployment. It's not going to affect or delay their ability to collect unemployment. COBRA coverage as well. If you provide COBRA coverage, you're paying for an individual, while they're collecting COBRA, you're giving them money toward COBRA, they still can collect unemployment. It's not going to affect or delay their ability. Only fringe benefits, because those are considered wages, right? Wages are disqualifying income that will affect or delay an individual's ability to collect unemployment. Next slide, please. What if you're very generous, right? You're a very generous employer, and you decide that you want to supplement an employee's wages while he or she is on furlough, right? So I had some clients that weren't necessarily paying the employee's wages, right? But they were giving every employee, we were calling it a stipend of $500, right? So again, it was a lot less than what the employees would ordinarily be getting, but they felt bad. They had the money to do it. So they were essentially giving employees a stipend. Will that, right, will my client who gave the employees a $500 stipend, right, essentially while the employee was collecting unemployment, will that affect their ability to collect unemployment? The answer is yes, right? Because that stipend really is still wages, right? Because we're taking taxes out of that. We're taking payroll taxes out of it. So the IDES will look at that as wages. So, for example, let's say that I ordinarily, in that situation, I ordinarily got $1,000 a week, and my client gave me, the employer gave the employee $500, right? I will get, to the extent, right, they're going to look at that and say $1,000, then to the extent that what you're providing me exceeds 50% of the weekly benefit amount, which it does here, right? Then you're going to see the individual will affect their weekly benefit amount, right? So the $500 I'm getting weekly benefit, $500 I'm getting in a stipend, the $1,000 weekly benefit amount, right? IDES are going to look at, take an average of the two. So I will not collect that $1,000, right? Because you're getting the 500. So in essence, I won't be collecting anything for unemployment because that's that 50%, right? So be very careful on that to the extent you're doing it. Next slide, please. What if you want to supplement an employee's unemployment benefits, right? I wouldn't recommend this because there's a whole process involved here, right? But to the extent some employers are doing this, you can, right? You can supplement state unemployment benefits, but there's a whole process involved here, right? This will not affect the employee's ability to collect unemployment insurance. So there's 3 requirements here. First, right, the individual must be eligible to receive unemployment benefits, obviously. The second, These payments must be made under a tax-exempt trust agreement or other contractual plan that grants the individual a vested right to receive these payments once the conditions of the trust agreement or contractual plan have been satisfied. And this trust agreement or plan must treat each individual similarly, right? So you can't say, well, we're going to give the Caucasian employees, right, we're going to supplement their unemployment benefits, but minorities, we're not going to do that, right? Obviously, for obvious reasons, that's not a good thing to do. So you have to treat everybody the same. Again, I wouldn't recommend this. It's a whole process involved, but to the extent you want to, I want everybody to know you can, but there's just a process in place there. Next slide, please. The CARES Act, right? So what is the CARES Act, right? We've heard this term. The CARES Act is a federal law that was enacted to address the economic situation resulting from COVID-19, right? This is a federal law that went into place several months ago, where the federal government was providing additional unemployment benefits to employees. They're essentially giving the state additional money, right, to provide additional benefits to employees, right? State funded, federal funded, not state funded. Next slide, please. So what unemployment benefits are available for Illinois workers under the CARES Act, right? The biggest one, I'm sure we've all heard about, is the CARES Act provides this additional $600 per week, right? Under that federal provided unemployment compensation program, added on to an individual's weekly unemployment benefit amount. So let's go back, if you remember, where we talked about when the employee, when you made an offer of reemployment to the employee, when the employee says, listen, I don't want to come back to work. I'm doing a lot better collecting unemployment. That may be the case. Why? Because let's say the employee was getting $400 on a weekly benefit amount. The $400 on their weekly benefit amount, they also are now getting additional $600. So now that person is getting $1,000 a week. That $1,000 a week may be more than what you are paying that individual per week on a 40-hour work week, right? So that's why that individual can say, listen, I'm doing a lot better on unemployment than I am coming back to you as the employer, right? Again, that's not a legitimate excuse to refuse an offer of employment. So long as same job, same hours, same pay, that individual has to come back to work. Remember, make sure you fill out that form if the individual, if the reason for the refusal is that. But that's why many employers are struggling now, because the employees are saying, listen, I'm doing a lot better. But know that that $600 per week under the CARES Act, that expires on July 31st, 2020. So this isn't something that's going to go through December 31st, right? After come August 1st, 2020, if someone's still on unemployment, they're only going to get that $400. Again, if they had a $400 weekly benefit amount, they're only going to get that $400. That $600 per week, right? They're not going to be getting that after July 31st. I got the question of, is everybody eligible for this $600? The answer is yes. Individuals, if you're eligible and you're getting even $1 of unemployment insurance benefits, you were able to collect that $600. Next slide, please. Okay, this is a continuation of the prior slide. So the CARES Act, right, which may be of interest to employers who use independent contractors, and I want to digress for 2 seconds after I talk about this slide. The CARES Act also provided $600, right, to Illinois workers who ordinarily would not be eligible for unemployment benefits, but who now are eligible under the CARES Act, what's called the Pandemic Unemployment Assistance Program. This, the acronym PUA, this program was put in place by the federal government for workers who would ordinarily not be eligible for unemployment. So here in Illinois, right, gig workers, right, we're talking about Uber drivers, for example. More importantly, true independent contractors. True independent contractors are not eligible for unemployment, right? They're not eligible for unemployment. So they are now, when I say now, they're only eligible for this $600 under this Pandemic Unemployment Assistance Program. Now, let me take 1 minute here to talk about independent contractors. because this is a trap that many employers fall into, unfortunately, and they get audited. So I will say that when I hear one of my clients or even a potential client say that they're using independent contractors, 99% of the times they're misclassifying that individual as an independent contractor. Then that individual likely is an employee. So what happens is this, scenario is this. And the IDES, even if you go on their website, they know that. So they are urging employees, even though you're claimed the title as an independent contractor, if you look on the website, they're telling employees still file anyways, because more likely than not, your employer is misclassifying you, right? So what happens is this. An independent contractor, you believe is an independent contractor, they file for unemployment. You get that claim, you can test it and say, Scott's an independent contractor. Red flag, red flag. IDES picks this up, right? What happens is they audit you. If they look and see there's many claims from individuals who you are claiming are independent contractors, if they're claiming employees, you're going to get audited. Folks, these audits are not fun. They cost a lot of money, right? So be very careful in that situation. So what I am telling my clients, right, and you can choose to follow this or not. If you have a lawyer, run it by your lawyer. But this is what I've told my clients. If you know that the individual is not an independent contractor, do not contest that claim. If you contest that claim, there's a good possibility you will be audited, right? Because particularly if there's several claims, right, from quote unquote independent contractors and you're contesting them as employees, the IDES will pick that up and say, okay, there's something fishy going on here. These people are claiming they're employees by what they're telling me they are, but the employer is claiming they're an independent contractor. You're going to get audited. They go back 3 years. If they find that you have been misclassifying them, not only are you now in trouble with the Illinois Department of Employment Security, you're in trouble with the IRS because you're not paying payroll taxes. You're in trouble potentially with the Department of Labor if any of those individuals worked there for 40 hours. It's a domino effect. So be very, very careful here. I wanted, again, take a couple of minutes to talk about that because I've handled these audits and that's how they happen through unemployment claims. All right, so to the extent they are true independent contractors that will get this $600 through the Pandemic Unemployment Assistance Program, but these PUA payments, they end on December 26, 2020, right? Also, under that CARES Act, know that ordinarily someone would be eligible for only 26 weeks of unemployment insurance. Federal government is picking up the tab for the additional 13 weeks, right? So now an individual, instead of 26 weeks, they're eligible for 39 weeks, right? 39 weeks of unemployment under this, under the CARES Act. So note too that not 26, employees are eligible for 39 weeks. Next slide, please. All right, so really quickly, mechanics of an employment benefits claim. What happens here? You're going to get the notice. The next slide will talk about that notice, right? You have to challenge it, right? You've got 10 days to do so. Make sure you can test it within 10 days. You will see on the next slide when I show you where that date is. If you do not contest within 10 days, you will be deemed to have waived your right to unemployment. Now, small caveat there. I've had some clients who got the notice after the 10 days, didn't contest, but still got a notice of hearing from the Department of Employment Security and asked me why, right? The reason is this. The Department of Employment is broke, right? So now, are they going to do this with every claim, right? You may not have contested past that time, that you didn't contest and the 10-day period has ended. No, but if a department feels that an employee is in fact not eligible, even if you didn't contest within the 10 days, you still may get a notice saying that you're going to get there's a telephone hearing upcoming because the department denied that claim and the employee challenged it, right? Do you want to leave your fate to that? No. Make sure you're challenging if you are going to within that 10-day period, right? If you do not, again, more likely than not, the department will deem you to have waived it. For those claims, the department looks at it and says, hold on a second, the employee is not eligible. The employee does file a claim. You will still get a notice, right, of an appeal, right? But it's up to the department as to whether or not they're going to allow you to, during that telephone hearing, and say, hold on, I want to protest it now. Because they're going to ask you, why didn't you do it within the 10 days? So be very careful about that. After that telephone hearing, you get a written notice of determination, right? You'll get another notice. And then, of course, the last and final outlet is the appeal to the Board of Review. So that's a very high level. Next slide, please. So this is a sample notice that I wanted to show everybody that you'll get from the Department of Employment Security, right? Look at on the right side of the screen here. The most important date on here is it says reply due date. Make sure you calendar that date. That's the date that I'm telling you that you've got essentially the date to respond, not essentially. You have to respond by that date. Ordinarily, you have 10 days to do so, but what's happening now? Mail is slow, right? You may get this notice on day 8, which means you have 2 days to reply, right? You can't call the IDES and say, hold on, I need more time. They're going to tell you, too bad. Too bad. You've got it within the 10 days. You've got 2 days right before that 10-day period to contest, if you're going to contest. By contest, I mean protest. So make sure that is the most important date on here, right? The other important date on here, reason for separation. If you look at the middle column under that notice of claim, that's the reason that the employee gave for separation. Make sure that's correct. A lot of times employees will say, hey, I was laid off. No, you weren't. We fired you, right? We fired you for a cause, right? So make sure you keep note of that. So again, this is just a sample form that I want everybody to know. Again, there's just a couple different things here. That reply due date really is the most important date here, because if you try to protest after that date, there is a good possibility you will be deemed to have waived your right to do so. Next slide, please. Okay, so that is the end of this webinar. There are some questions that I will address, but to the extent you think of any other questions that we have not addressed here today, here's my information, right? My telephone number, my email address. Feel free to reach out. Happy to address any questions. I'm actually quite frequently in the Southern Illinois area quite a bit. I've got clients in Decatur and throughout Southern Illinois. So I'm happy that the Chamber gave me an opportunity to conduct this webinar for folks here. But with that, I know there's a couple other slides. Let's go to some of these questions here before we actually conclude the webinar. So we've got 2 questions. The first is, how do I see which of my employees are collecting unemployment that is being charged to me? So you should be getting a notice. Each quarter, you will get a notice from the IDES showing which one of your employees, first of all, that notice that I sent to you, and that was on the previous slide, that's how you're going to know who's applied, right? You're going to know who's collecting because you'll get a subsequent notice after that if the employee is deemed eligible from the IDES saying, Scott is eligible, he's going to be collecting, this is what he's going to be collecting. And then after that, each quarter, you should be getting a notice from the Department of Employment Security telling you who is still collecting unemployment. So that's how you're going to know, right? Well, you'll know because you'll get the notice saying that I was approved, right? But then after that, you should be getting quarterly notice from the IDES telling you each quarter, right, who's collected, and this is how much they've collected, right? So that's how you're going to know. And again, if you know that an employee has been subsequently reemployed, remember that form I showed you to the, or if you go on the department's website, right, and click under employers and click under the link that says report fraud, right? There's that link there that has that box with the drop-down box. If you know that someone else, that one of your employees got another job, fill out that form, submit it, right? They shouldn't be collecting unemployment. All right, next question. Can an employer require a furloughed, so this does not deal with unemployment, but I'm happy to answer that question. Can an employer require a furloughed employee to be tested for COVID-19 prior to bringing them back to work? While not an unemployment question, certainly a question that many of my clients have had. The answer is yes, but there's a distinction here. So there's 2 types of tests. There's an antibody test, right, to determine if someone has developed an antibodies to COVID-19, and then there's the virus test. Just last week, the EEOC has said that employers cannot require employees when they come back to work to take antibody tests. You cannot require that, right? To get an antibody test to determine whether or not they have antibodies, right? So someone who already contracted COVID-19, did you develop antibodies to COVID-19? You cannot require that of your employees. But you can require the employee to take a virus test, right? And the virus test is to determine whether or not someone actually has COVID-19. That you can require from them. That being said, if you require it from them and the employee is charged, right, is that covered by healthcare or their health insurance, or they have to pay a copay, just know you are liable. You have to reimburse the employee for that copay, right? Remember, January 1st, 2019, the Illinois Reimbursement Act went into effect. That act says that employers must reimburse employees for any necessary and reasonable business expenses. If you're requiring an employee to undertake a COVID-19 virus test before you allow them to come back to work, quite frankly, which you should be doing, then an employee has to pay that, let's say a $20 copay. You have to reimburse the employee for that copay, right? That is a necessary and reasonable business expense. A lot of employers aren't doing that. You can get into trouble for that, i.e. class action lawsuit. So make sure you're reimbursing your employees to the extent they have to pay any out-of-pocket expenses. So with that, I know there's a couple other slides. Kristen, if you want to just quickly go through those. Thank you again. And again, Norm, I'm not sure if you want to talk about this particular slide. Then I've got one last slide that I'll talk about as well.
Sure. I want to just thank everybody as we conclude the webinar. Thank you for joining us again. Thanks to Bank of Hillsborough as our sponsor, and thank you, Scott, for joining us. That was very informative. Lots of information to absorb, and hopefully everybody. I want to remind everybody that the webinar was recorded. It will be available in our Business Advocate email tomorrow morning. It'll also be posted on the Chamber's YouTube channel, as well as all the previous webinars that we've held. So if you ever want to go back and review this information or any of the others, it's always available to you that way. You will be receiving an evaluation form in the mail, or excuse me, by email, that we would ask you to please complete and send back to us, because we do value your input, and as I said earlier, and your suggestions for future webinar topics. Scott, before I wrap up with information about next week, do you have some other things you want to mention?
Oh, just the last slide is just a legal disclaimer slide that I have to, we can go to the next slide. Yeah, so while I am an attorney, this is a legal disclaimer. Of course, this is not, since there are no attorney-client relationships here, nothing I said today is considered legal advice, right? To the extent you have any specific issues, make sure you seek the assistance of an attorney, and hopefully a competent one at that. So that's the only thing I wanted to say. And of course, again, if anybody had any questions, you'll get the slides. My contact information is on there. We did go through a lot of information here in a short period of time. So feel free to reach out to me. I'm happy to answer any additional questions that folks may have. That's all I have.
Okay, I did post in the chat box the website of the Department of Employment Security. I'm sure most of you have that, but if you don't, I did post it in the chat box for everybody. Next week's webinar is on Thursday, July 2nd at 9 a.m. We're going to be changing things up a little bit for the next few weeks, and we want to offer you some motivational speakers. I think that we've witnessed the need to bolster our spirits as we continue to deal with the pandemic and other civil unrest that's occurring across the country. So we're bringing you a couple of motivational speakers, and really we're thankful for these individuals for volunteering their time to do these on July 2nd. Our speaker is Dr. Tom Hill, who is an author, speaker, and entrepreneur. He's actually been here in Effingham a couple of times and spoken for the Chamber. So after leaving a 25-year career in education, went into real estate and now leads a coaching team focused on his idea, 6 measures. So please join us for that webinar, and then we'll talk about future webinars. Thank you so much. Have a great day. Bye.